Morning, Mr. Harris. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
This case on docket or is it off
No, it's a walk-in.
May I get the cause number?
Yeah, it's 2-5. Go ahead.
And then after I say it, I need to pull it up. It's 254, counsel. 5144.
Thank you so much. On December 27th, 2024, in Harris County, Texas, officers were dispatched to a family disturbance call, and upon arrival, the officers met with the complainant's son, who stated that his parents were fighting. The officer met with the complainant, who was not cooperative, but stated that the defendant choked her, causing pain, and reported pressure of a 7 on a 1 to 10 scale. And then the officer then observed a large bruise on the complainant's arm. The complainant's son stated that the defendant.
This is where every courtroom viewer should perk up. Probable cause isn't guilt. It's just the judge saying, yeah, there's enough here to move forward. But look closely, a bruised arm, a 7 out of 10 pain report, and a son saying, this isn't the first time. That's not minor. And remember, Texas takes family violence cases personally. So while this judge stays calm, he's already thinking, can I trust this guy not to blow again? What do you think too harsh or fair caution?
Had abused the complainant for a very long time, and that this is not the first time he has choked her.
Mr. Harris, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
I'm entering in now what's called a magistrate's order for emergency protection. That is a court order that identifies Ms. Pisana as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat or harassing behavior, be in possession of a weapon, or go within 200 feet of the Buffalo Bend Drive address. Do you understand? If you violate this, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. Do you understand? Okay,
Let's speak briefly.
please.
The state has had a chance to talk to the complaining witness this morning and on January 2nd, and the complaining witness spoke with officers at the time of the investigation and said that she did not want to press charges, that they had a dispute and that it was not, as talked about by everyone else. She was not saying to anyone that she was choked or anything else, and they spoke with her this morning. She only wants a protective order against violence communications between each other. They've been married for 7 years, together for 19 years. They were together as much as yesterday, Your Honor, and that's not what she's looking for. She's looking for resolution of the case. They have a home together, they live together, raise their children together. Mr. Harris has been employed at the same company doing construction work for the last 20 years. They're fighting a foreclosure on their home. Having him move out to try to find somewhere else to live would make them keeping their home impossible.
My only concern is the violence. And my major concern is the fact that we have here children that are exposed to and see continual violent behavior. You know, when a kid sees that, what happens? You know, that's a huge concern. We have, did the child say that this happened?
Said that it's not the first time.
Well, the son was not present at the incident. I think.
Well, I don't know that.
Yeah, that's the thing.
I mean, all I know is that a child telling an officer, hey, man, you know.
Your son is 18, does not live in the residence, came to the residence as they were getting into it. So would not have been there, would not have saw interaction before. But the facts will lay themselves out, and we'll look to that, Judge, but we are asking the court would consider that.
Guys, what do you say? You heard the facts, right?
Yes, sir.
He wants to have contact.
I just spoke with complainant and she requested no negative contact. I gave her the options of no negative or no contact altogether, and she said no negative.
So you think contact's okay?
I would defer to you, Your Honors, that's what she said, but no contact, the more restrictive is fine with us.
What scares me is that even, you know, they're going through even a more stressful time. You know, if their house is in foreclosure, it adds upon more stress. So we have these facts that are pretty bad. We've got more of a stressful situation happening now. The last thing I need or want is for anyone to end up on the news because someone does something rash that you can't recover from. You know, the thing is that when you pick up these criminal cases, right, you've dug yourself a hole. You've dug yourself a hole, but the hole is not so deep that you can't get out of. Sometimes people dig themselves such a damn big hole they never get out of. It's continually on the news every single day. 90% of the people that you see in jail, because they don't have any self-control. They get upset, they wig out and do whatever the hell they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Because when stuff of this nature happens, it affects everyone. It's like a cancer. It radiates everyone, affects everyone. And with the stressful things that are going on now, it scares me to allow contact because I don't want any further. I don't want anything worse to happen. I don't know. I don't know.
I understand, Judge. Mr. Harris has no criminal history. This is the first allegation. I know we hear in the office report about it happening in the past. We've never had any action with law enforcement in something like this. I don't have any doubts. I've known Mr. Harris and his father for many years now, and I don't expect anything to happen, but you're right. I can't stand before the court and say that. And Mr. Harris can do everything that he can do to ensure he's used coping techniques. We've talked about him since I've been representing him about leaving the scene.
This right here is the heart of Texas courtroom reality. The judge isn't just scolding, he's educating. Notice how he flips from law to life lessons, self-control. It's not what you think, it's what they perceive. That's gold. One wrong move, even a gesture, can trigger a violation and land you right back in jail. Judges like this have seen too many people ruin second chances, and he's practically begging this guy not to be one of them.
It's not in the report, Judge. There's some things that we have to deal with alcoholism within the home that he's trying as a husband to work through with his wife. So there's some things that need to be done, Judge, but he's been responsible.
That's the other thing I was going to say. I don't want you consuming alcohol or illegal drugs. I'm going to test you. If I find that you're consuming alcohol or illegal drugs, you pick up a new case, I'm going to put you in jail. I'm going to tell you now, I will do everything in my power to protect my community at all costs. I don't care who is in front of me. I don't care what gender, color, or your small farm animal. I don't care. Do you understand?
Yes, sir.
The problem is that, and what you need to understand, what is threatening or harassing doesn't matter what you think. I could care less what you think. It is what the other person perceives. So can conduct alone violate this? If I go like this, is that threatening or harassing? It most certainly is. And they can land your butt in jail in a moment's notice. Do you understand?
Sir.
How long ago did this take place?
December 27th.
27th of 2024, yeah,
So it's been a couple weeks already.
a couple weeks already.
I will allow you to have contact, but no threatening or harassing contact. And I'm telling you now, between now and the next setting, I'm going to test you for drugs and alcohol. And if I find that you're using, I will lock you up. You have to imagine that if you're in jail and the bond is set at 10 to 20,000, if you don't have anyone to pony up that kind of money, you will be stuck like Chuck until this thing's over with. Do you understand?
Sir.
Self-control. We all get upset. I have 4 kids. They drive me up that freaking wall every single day. But if I try to beat them into submission, it only makes things worse. Because hell hath no fury like a scorned woman and a teenager who's out of control. And when they see that type of what's going on, it's okay. They think it's okay. It's not.
Understand.
All right. Okay.
Judge,
So you will be monitored by pre-trial. No threatening or harassing. He can go back home for now. But if I hear anything else, I'm going to unleash. You understand?
Sir.
Okay.
Your Honor, will we be excused for him to get with pretrial on the pretrial bond?
Oh, yeah.
He's a bond set, and I'm hearing no up being signed.
No what?
No more.
No. The MOAP is going to be granted.
Okay.
I'm entering in the order for protection. Everything in that order is stuff that you shouldn't do anyways. The only thing I'm taking off is the residential restriction. Everything else stays. So if you make any threats, they're going to file another case on you. And I'm going to tell you, it's the capital murder of misdemeanors. You pick up a violation of protected order. Does he have any criminal history?
No, Your Honor.
All right, I'll set bond at $100. I'll grant you a PR bond. It's the only one you're going to get, though. You understand? Okay, guys.
We
You got
stand.
it. You got it. Thanks.
Come on up.
Hey, finally. Mr. Bose,
Good morning, Judge.
it only took 6 years. How are you,
Only?
Mr. Das?
Happy to be
We're
here.
fine.
You're set.
We're happy that you finally made it after all that time, you know?
Thank you.
Yeah, so, here, let me let Ramon in. All right. Mr. Das, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. I seriously have to commend your lawyer, Mr. Bose, who has just literally stayed with you 1,797 days old, and she has never, ever forgotten. Mr. Bose?
Yes, Judge. Good
yourself
morning.
On the back, really. Just,
Awesome.
you
Thank
are,
you.
you are one and amazing.
Oh, thank you, Judge.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 13th, 2020, officers were dispatched in regard to a major crash at the exit ramp of Bingle and Pinemont on Northwest Freeway. And the officer made contact with the defendant, who was observed sitting in the driver's seat with the keys in the ignition, with the vehicle still running, and the defendant was covered in vomit. The officer smelled a strong odor of an alcoholic beverage and observed bloodshot eyes and slurred speech. The officer further observed the defendant driving the vehicle and swerve across several lanes and strike a Toyota Sienna van. And that they followed the vehicle, and that's whenever they pulled over the vehicle and made contact with the defendant. The officer made contact with the complainant, who did not see the driver or the car hit them. They just felt the impact, which caused their car to spin out of control. And the officer then conducted standard field sobriety test, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to breath. The results 0.112 and 0.118.
You said he was in the driver's seat when the
He was
cop
observing
came
the
up to
driver's
him.
seat still running and keys in the ignition.
Mr. Das, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You are also not allowed to drive unless you have a valid Texas driver license and liability insurance. Do you understand? Okay, you've got a great lawyer. Listen to her. She'll take care of you. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but just stay in touch with her. She'll tell you when you need to come back and what to do.
Sure.
Do you see a valid license?
I'm writing it right now, Your Honor. It's eligible.
Great. So for now, I'm going to have you sign a receipt with Victoria. We'll have you get with pretrial for your bond conditions, and after that, you're free to go. All
Sure.
right,
Thank you.
please.
Judge, how's March 4th through the 6th?
Thank you, Judge. May I be excused?
No, we need a date. Hold on. How's
Oh.
March 4th through 6th? You say.
That is a national holiday, the day that the Queen was born. How about,
Is that your birthday?
yes, my birthday is the 7th. So let's do the 4th. Let's do the 4th. And yes.
Okay.
Thank you, Judge.
Hey, have a great day.
You do the same, Judge. Bye-bye.
You are charged with violation of a bond or protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 8th, 2025, in Harris County, Texas, the officers were conducting surveillance on the defendant, who had active warrants out of the 178th as part of a fugitive task force when they observed the defendant's vehicle parked at a location where the defendant was prohibited from going due to an active protection order. The officers then observed the vehicle drive away, driven by the complainant of the defendant's open case in the 178th. The officers then observed the vehicle to have an expired registration and initiated a traffic stop. The officer then found the defendant hiding in the back seat. Both the complainant and the defendant acknowledged that the defendant was prohibited from the residence.
So she was at the
She was at
residence.
the complainant's residence, yes.
Was she with the complaining
With the
witness
complainant.
as well?
Yes. They
Okay,
were
so
together.
how bad are we talking the ag assault? Do you mind telling me about that?
I'll tell you about the aggravated assault, Your Honor. So in the aggravated assault, the officers were
And there it is, the nuclear option. 0 bond. That means no release. No bail locked in until trial. The judge's voice shifts here, protective, not punitive. He's saying, if you test me, I will use every ounce of my power to keep others safe. You can feel the weight, every word is a line in the sand. Question for you, should judges have that much authority when emotions are still raw? Or is it exactly the safeguard people need in moments like this?
dispatched to a disturbance, and they met with the complainant, who stated he was involved in a verbal altercation at a bar earlier in the morning. And then once the complainant arrived home, he was locked out of his house and had to force the door open. And that started another disturbance with the defendant. The defendant threw several items at the complainant, and the defendant began to strike the complainant on the back of his neck several times with their hands. And the officer observed the complainant to have red scratch marks on his neck. Further, the defendant retrieved a black compact handgun and pointed at the complainant and racked the slide, thereby placing the complainant in fear for his life.
Okay. Esquivel, I'm going to find that there's probable cause to go forward with your case. I want you to understand something very, very clear. The Texas Constitution does not allow me but in extremely limited circumstances to hold someone at bond. 0 bond. This is that situation. I'm going to put a protective order naming this person as a protected individual. If you so much as do anything to violate any of these conditions, I can have a hearing to hold you at no bond. And I will do it in a heartbeat to protect every person in my county. Do you understand? You
Yes,
are not
ma'am.
to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. No weapons, no contact with the complaining witness, and no going. I'm assuming, is it a he, she? Well, it doesn't matter. You're not to have any contact. Don't go anywhere where this person lives, works, anything. Do you understand? I don't want to talk about the case, but
President, I'm a little
Oh.
confused.
who's your lawyer?
Robert Valles, and he's on my case. He was supposed to be here this morning. I'm a little confused.
Do you know, has Bo said he's going to show? We had no idea that you have a lawyer. Okay, so let's do this. What I can do is I can have you take a seat. We'll wait for him to get here. But regardless, I'm putting these conditions on your bond. I've found that probable cause exists to go forward with your case. The only thing I'm telling you now, don't violate any of these conditions because there are severe consequences.
Yes, Your Honor.
We'll go through it again when your lawyer gets here, but just don't leave until he gets here, okay?
Your Honor.
For now, I'm gonna have you sign a reset with Victoria. We'll have you get signed for your conditions. Just take a seat momentarily. Well, once he gets here, then we'll go through it.
Yes, Your Honor.
Okay.